For Creamer Media's Polity, I'm Sane Dhlamini. Researcher and analyst Professor Raymond Suttner joins me to discuss how court recognizes democratic rights of rural communities. Welcome, Professor.
Thank you.
Why do you think this case is so important?
I think the whole question of how customary law is treated is very difficult because customary law comes along with traditional leaders, and the government at the moment favors a version of customary law that is static, unchanging, and undynamic. And why I think this case was important, and there was another very important case, the one in the Constitutional Court regarding the communal property association in the Northwest. These cases are both important because they assert the claims of communities that it's not just a hierarchy with what the traditional leader decides going. Now, in this particular case, they recognized what is probably not a custom in most parts of the Eastern Cape, that the community had the right to elect the headman. And before upholding their decision, they had oral evidence from Professor Lungisile Nsibeza, and it was uncontested evidence. And what he argued is that in this part of Kala Reserve, there was a custom for over 100 years whereby the community elected their headman. And even under the Bantu Authorities Act, when they tried to impose the Bantu Authorities Act, the community successfully asserted their right to elect and not have the headman appointed. Now, it's quite important in the sense that the headman is not as remote from villages as the chief may be. So the headman, if the headman is an elected person, he's more likely to be responsive to the concerns of the community, things like this. Now, when this decision was made, it was a decision of the full bench of the Eastern Cape High Court, because there had already been an interdict to prevent the chief from appointing someone. Now, when the previous headman indicated that he was going to retire in 2012, the community held an election and they elected someone. But the chief simply ignored this and arrived there with one of his relatives to inform the community, not to consult with them, to inform them that this was to be their headman. And the court said, first of all, the High Court had set this aside and instructed the headman to vacate his position. He continued to receive a salary and to ignore the decision to such a point that they had to issue a warrant for his arrest. Eventually he was fined. So what you have before this is a situation of defying of court orders, according to one report, because the headman did not believe that he had to abide, what may have been the chief didn't believe that he had to abide by a decision with which he disagreed. So when it came to this High Court decision, the court said this may not be the custom in other parts of the Eastern Cape, and he was opposed. It wasn't just the chief, it wasn't just the headman who was sitting there, but the MEC for Traditional Affairs in the Eastern Cape and the Premier were also fighting this case against the community. And the court decided that the legislation in the Eastern Cape said that the headman had to be appointed, had to be put in place in accordance with the custom of the area concerned. Clearly the custom of this area was that that person had to be elected, and it may not have been the case in other areas, they acknowledged, but this had been established as custom. Now that is very important, because what they are recognizing is that custom is not one thing applied everywhere. Now, under apartheid, you had what was called Bantu law or native law, and that law, they tried to make it more or less uniform, but what the court recognized is that custom may vary. It's a notion of living custom, that it may have been the same sometime in the past, or it may have been different, but whatever the character of the custom is, that living custom has to be recognized. So for that reason, I thought, first of all, it was a learned judgment, learned in a sense of taking account of the history of the area, of the Bantustans, and the fact that if the headman was appointed by the chief, they would actually have had less rights than they had under Matanzima's Transkei. So for all those reasons, I think it was a very important judgment in terms of courts coming to the rescue of communities in the rural areas who may not have their democratic rights respected. And I think it's important to recognize that this is a counterweight to the ANC and government allying themselves with traditional leaders against communities, and that for that reason, it wasn't that the court said, no, we don't agree with the government or the ANC. They just said, this is what the Constitution means, this is what the Eastern Cape legislation means.
And now, do you think this will have any lasting effect in terms of undemocratic tendencies of traditional leaders?
You know, we have the other case in the Constitutional Court where the Chief Pilane had undermined the rights of communities in relation to a land claim, and the Department of Rural Development had actually collaborated with him. We have the situation in this case that I discussed in the column, where they actually defied a court order. So there is a tendency towards lawlessness, and then the question arises, if there is that tendency, will communities always have access to lawyers to challenge this? Now, if you think of how big South Africa is, not every community knows that they actually have constitutional rights. Although what I think is very interesting, some of these villages, people who can't read, actually hold up the Constitution and they say, somewhere in here, I think there is some right here. So that there is a sense in quite a lot of rural communities that they have rights under the Constitution, but there may not be in some places. And we must understand that poor communities without resources need lawyers if they're going to go to the High Court or even the Magistrates' Court. So the question of extending the legal aid system in South Africa is very important. It doesn't really help people who bring civil claims. This is a civil claim against government officials. It's not a criminal case. It's where the state prosecutes. This is something where you sue or you bring an application for the court to declare what your rights are. Now, I wonder how many communities have not had access to the Legal Resources Centre or other centres that can assist them in cases like this. So that is a barrier, and I think the fact that government seems to be intent on supporting the chiefs against the communities in land claims, in undemocratic rule, a whole lot of other things. But what I think this case and the Constitutional Court case shows is that they are going to have difficulty insofar as what they're trying to do runs against the Constitution. Once it reaches the High Court, and especially the Constitutional Court, where the decision was also unanimous, they are going to have difficulty. So I think this is quite a good omen in a very difficult situation.
Thank you, Professor. That was Professor Raymond Suttner speaking to Creamer Media's Polity about how courts recognizes democratic rights of rural communities.